I'm going to share my screen, if I may, if I've got permission to share my screen. So let's see what I can do on that front. Okay, don't know if this is coming up at all. Can people see my shared screen?
Yep, thank you.
Fantastic. I'll go full screen now, if I may. Does everyone see the full screen?
Yeah.
Fantastic. Great, off we go. I've got about 20 slides. We've got about 15 minutes. Happy to take questions afterwards. But on this first screen, I'd just like to point out where I've highlighted in yellow a few words. Intellectual property now affects everyone. It affects every small business, whether you're registered or not. And it affects you, especially if you're a small enterprise, because the Intellectual Property Office, the UK government registrar, has released in the past statistics indicating that 1 in 3 small enterprises now suffers from IP infringement. 1 in 3. And as we've got 5 million of them in the UK, that's a big number. Most people aren't aware of this very, very high number and the impact it has, because most of these cases of infringement are settled by lawyers out of court under many of them under non-disclosure agreements. And that's why this is a very big problem, because we have a lack of education and training and awareness on this topic, largely across the small enterprise market. And so as a result of this presentation, I'm hoping for you to go away with a better understanding of the risks, but also the opportunities that IP protection will afford you. Coming back to my highlighted words, ahead of a curve, that's one of the phrases that I now own. I've trademarked that as a phrase. You can see the letter R in a circle, which indicates registered trademark. And it's great to have a phrase like that, because a lot of people who have slogans or mottos can actually register them as their own, as their trademarks, and they become more memorable alongside their branding. You'll see also that I've registered as a trademark my domain name, Consult SMP. And I do that for a number of reasons, but primarily because it stops other people buying similar domain names and competing with me online and potentially taking my inquiries. So registering your domain name can be helpful. And I'll give you some examples towards the end of the presentation as well as to why it's worth doing that. And then finally, my name, Strategic Management Partners, whilst these are common words, it's a common phrase, I can register that as a trademark by having that phrase included within or alongside a unique graphic logo. So here are my 3 trademarks registered. I've got more on my website, but I want to make sure that you understand that there's more than a brand name involved in registering and protecting your trademark and your branding. So let's move ahead and see what we can do about protecting you. What are the benefits, first of all? So I've mentioned that having a domain name in my name registered, I stop people using that domain name to take inquiries thinking that they're talking to me. But also, if you're using a brand name, it does prevent people from taking your inquiries online. You may be aware sometimes that people buy Google AdWords, which appear above your company name. And the purpose of that is to encourage people to take their inquiries to other parties. So it can be a protection against Google AdWord buyers as well. It's improved my SEO visibility substantially. So if you put my company name or my logo into Google or my personal name, you'll see me on page 1, which is a tremendous advantage for a small enterprise, especially little old me, working at home as a sole director of a limited company. Domain name costs can be avoided because if you register a domain name, you automatically own and have rights over other associated similar domains. So you don't have to keep buying domain names to protect yourself. It's a fair advert for business continuity, which is great. And as I mentioned in my introduction, as an ESG, environmental social governance advisor, having intellectual property protection also improves my standing when I'm bidding for public sector contracts. And then finally, we come to infringements. You may not be aware of it, but a sole trading director can end up with a financial penalty of over £100,000 by having a single trademark infringement case against them. I had one last year, just a simple logo, which was similar, not the same, as a registered trademark logo, and he was asked to pay £150,000. He had to stop trading in his current business, close the business down, and then rebrand. It's a significant problem, so let's find out why and what you can do about it. But first, let me just emphasize this is a very, very wide problem. Here are the official statistics from the European Union Intellectual Property Office, and you'll see here that infringement claims are unfortunately very common. 24% for very small firms, up to 39% for existing SMEs. And the reason for that is often that small firms can be targeted well after they have created unknowingly an infringement. And sometimes it's better for lawyers to make a claim after they've been trading for some years, because they may be able to claim up to 40% of a small firm's historical profits. That's a big hit to avoid. Lots of new companies are now being registered on Companies House, and many people think that Companies House registration is a protection of their brand. The answer is no. Many companies registered on Companies House are in fact infringing existing trademark owners. So just Companies House registration is no protection. I always recommend, before you register a company name on Companies House, to check the IPO database for registered trademarks and designs, or ideally use a third party who's trained to do that for you, because there are millions of trademarks and designs on those databases. That means that many, unfortunately, are not protected. Approximately 95% do not have protection on Companies House after they've been trading as a startup. So it's a really big problem. And you can register and protect not just your name and logo, but slogans, shapes, pictures, graphs, and even business processes. That is how you take your clients through your business, how you operate, because once you're registering those as designs, it means that it's a criminal infringement if people try to copy them. So much stronger than a copyright infringement, which is usually just a civil claim, which means that you have to pay out of your own pockets to defend it. So trademark and design registration, often criminal infringements, which means that you can refer those cases to government bodies. Here's a small example. True Life, this domain is for sale. It's on sale in the USA for $29,000. You can buy it now. And if you proceeded to buy that now, you would be buying a registered trademark, because it was registered back in 2002. It's been renewed. And indeed, the current cost of a domain name infringement in America is $33,000. And indeed, Donald Trump has made a number of claims recently for domain name owners because he is very keen on litigation, as you may know. So be aware that domain name ownership should always be searched and checked properly before you make a purchase. More good news. It's a very simple process for registration to take place, but you must always start with a search to check if your brand name or your logo or designs or anything similar to those is already registered. You can then, once you've checked the registrations and you've got a clean sheet of health, make an application. The Intellectual Property Office will publish a trademark for 2 months to check if anyone else wishes to object, rather like the marriage bans. And if it's a design, it only needs to be checked and processed for 4 weeks. And then registration takes place with you getting a certificate. And that certificate, in some cases, can be affordable. So if you're wanting to register designs with the IPO, their fee rate for a single design is just £60. That's 5 years, renewable up to 25 years. The UK IPO charge for a trademark £205 for a trademark in a single trading category. That's for 10 years and it's renewable for life. So these things are affordable. There is an additional fee for any advisors who wish to help you with those registrations. I always recommend you take advantage of advisors. We'll come to that in a moment as well. But you can get free advice and support. On my website, there's a reference point there, but always look for advisors who are giving free advice and support because it makes it easier for you to understand the process. And once you're protected, you can use that letter R in a circle for registered trademarks or the D in a circle for registered designs. It's a great way to advertise and deter third-party copycats. If you do decide to try and do something yourself in terms of registration, be aware that about 10,000 people in the UK every year doing it themselves fail in their applications. And often those applications are forwarded to third-party registered owners who may decide to take action against them. So be aware there's a big risk in doing it yourself. Common reasons for rejection also include a lack of distinction or inventiveness that needs to be unique to you. Often people don't search the registrations, and often they don't search for unregistered branding, because unregistered brand owners also have protected rights and may claim unlucky followers for passing off, i.e. piggybacking on someone else's brand reputation. Objectors can occur during the publication of a trademark, so you need to understand how to handle or ideally pre-handle those objections. And indeed, please bear in mind that more than one trade classification can be protected. There are 45 classes in total. That really requires someone to give you advice who's trained to do that. So lots of reasons why it's worth talking to a trained certified IP professional. Even the professionals can make mistakes. Here's an example. The creator of the trunky on the right has claimed the kiddie case on the left has infringed its design rights. The kiddie case actually won their design protection. And the grounds for that were on the basis that Trunky on the right, the UK designer, had failed to register derivations or variations of their design. And they could have done that in the same application for a cost of £50. So as a result of that, the UK designer lost in the region of £6 million worth of revenues to a rival who came up with a sufficiently distinct design and has created a new product built abroad. So these things need to be checked properly by professional advisors. Further warning for you, and that is it's increasingly evident that online internet service providers who are seeing unregistered, unprotected products and services selling well often copycat them. If you have a registered design or trademark, all you have to do is send that certificate to the ISP, the internet service provider, and their policy is to automatically reject and remove any copycats online. They will do that very quickly. So bear in mind, if your branding or your products and services, or even your clients are being sold through ISPs, if they're not protected, there's a very high chance of a copycat occurring, and that can lose them a lot of business and their brand reputation. Giving a small example here of a lady who created an advent calendar recently. The advent calendar had some wonderful gifts behind each date. The calendar was selling for £149 online, but within just a few weeks, she had 900 copycats from abroad who copied her design and parts of her website, who then asked people to pay £49 for a product. People paid for that amount and they received nothing back, and they disappeared into the ether afterwards. So it did damage her business significantly. And what she should have done was simply paid the IPO £60 to register and protect her design, because then copycats would have been rejected immediately from any ISP. She didn't do that. She's learnt the hard way. But bear in mind, these cases are occurring every single day. It's a big problem. And it's a big problem for authors and any content developers and creators, because AI is coming now into the marketplace. A lot of people are putting information through AI chatbots, ChatGPT in particular. And when that happens, the AI system records, remembers, and indeed is starting to share that third-party content with others. I've had to look at recently people who are using AI to generate content for their website, because that content has copied from other website users, successful websites, and created a copyright infringement problem. The same applies to designs. So where people are using AI to help with their design work, AI is simply taking and assimilating good quality designs already online from third parties. And if any of those third parties have registered designs, there's a problem there. So these are issues that now are increasing the likelihood of risk and infringement. A couple of examples here. Lovely Yorkshireman was offering a jet washing service for people's driveways. He called it Easy Jet Wash. And he has been sued successfully by EasyJet Airline. He's been fined 40% of his background profits. He's lost his business reputation. He's had to totally rebrand, because the EasyJet airline has got now an internationally recognized brand, which gives them powers of ownership over other trading classes. So if you're using a word, your clients are using a word which is associated with a very well-known brand, be aware they may be at risk. Similarly, Harrods, the big H here, which I bought a nice bottle of rum from locally down here in Sussex, could be a risk from Harrods IP attorneys, because it looks confusingly similar. And a well-known case here, this single logo cost the user £242,000 in an infringement case, plus the legal costs. Effectively, they lost 41% of their net profits to the owner of the registered trademark, because it was deemed confusingly similar. Big numbers, big risks. What's the good news? Well, if you own a registered trademark or design, or registered business content, processes, or even training information, you can actually license that stuff. And I have a client who provides breathing techniques. He's now licensed his program of breathing techniques to 100 people in Canada, actually also another 50 in the UK now, each of whom pay him about £2,000 a year. So he has a nice passive income, £200,000 to £300,000 a year. The fees that enabled him to do that were about £1,000, so it's a pretty good return on investment. Most people have got content or IP that can be licensed to third parties, and there's an immense marketplace outside of the UK that really enjoy English designs, English speaking content for training, consulting, and other purposes. So worth exploring potentially to look at licensing, but you do have to be the official registered owners of the IP. And now finally we come to Helen and resilience continuity. Helen approached me about a year ago to protect her brand name. So the first thing we did was a search. You'll see that Helen's domain is resiliencecontinuity.co.uk. So the first thing I did was go online to domain names to find out if there were potential clashes. And I found one, resiliencecontinuity.com. Potential clash, needed further investigation. But this is how easy it is to have a potential issue where perhaps inquiries could go to other parties without you knowing about it. I also did a Google search for Helen. I found 116,000 results for resilience continuity. I managed very quickly to identify any other potential issues within Google, and then went on to Companies House to do a further search of registered company names, where of course there were some similar company names. And what this tells me is that if people have got registered company names which are similar, there's a likelihood of some of those companies also having registered trademarks. So onto the registered trademark database in the UK, and we found some who are similar, and we decided that actually the words resilience continuity as a trading brand name were a risk. So Helen came up with a new design with the words resilient continuity, but with a unique design which shows those lovely pogs in the work, which enable her to register and protect her trademark as unique, which she has now done, along with the design registration. So even if you're using similar words like resilient continuity or strategic management partners, you can register and protect those if you're using and creating a unique design or logo or typographical style with them. So in summary, let's just recap. Please consider your domain names. They may be at risk, and in order to overcome those risks, you can use graphic design to do that. Bear in mind that where you use the letters TM, that means it's not protected. Only the R in a circle signifies registered protection. I encourage you, if you've got a registered trademark, to put it on your website, as I have done there. I encourage you to consider using non-disclosure agreements with any staff, contractors and clients to ensure that they're not taking content, especially if you're making proposals which enable them to share those proposals if they're not properly copyrighted on each page. If you're using a third-party advisor, please ask for their certified credentials. Look at their websites, look at their LinkedIn testimonials, and ask, are they also certified mediators? Because infringement costs are very high unless you adopt mediation. The UK Intellectual Property Office provides a list of their certified mediators. I happen to be one of them. And our costs for mediation are significantly lower than going down the legal and court prosecution route. To give an example, my most recent cases have been resolved for a cost of between £200 and £300 instead of £5,000 to £10,000 going through a legal process. So check these things out, get some quotes, check if they're offering free advice as well. And if you want more information, then the answer is please contact me or have a few questions to ask right now. I'm going to stop sharing and I welcome a Q&A. Thank you.
Thanks, Clive. Some really, really, really important, great points. And I know particularly Joe has probably got a lot of food for thought coming out of this. Any questions from the
Well,
group?
you have been nagging me for about a year.
I know. I have recommended you on multiple occasions,
Yes.
Clive. To go.
I'm just a bit of a
yeah.
I'm just a bit of a
Yep.
procrastinator, which is where it all goes a bit wrong, isn't it?
Yep.
Yeah.
Yeah.
And also I'm not. Yeah, but I will be ramping everything up from the end of this year. Okay.
Yeah,
Suzanne,
the icebergs are out there, Joe.
Yes, I
and
know.
they're not always visible.
Especially because it's resilience by design and everybody's using it.
Yep.
So Suzanne, just so you know, Helen and I know each other really well. That's why.
Oh, okay, got it.
We're talking to each other like this. That's why she's nagging me.
So Joe, what are you going to do differently now?
Gonna ring you.
With a bit more enthusiasm.
And think of your clients and suppliers as well, because it's not just about you, it's about all the other 5 million small firms out there who are vulnerable and at risk and taken advantage of through lack of education and awareness.
So my focus next year will be, when I come off this FTC, is going to be small businesses for resilience and the insurance world. So it's all that, because that's the worlds I know. Well, and transport, but network rail.
Bear in mind, you can insure against IP loss. If you want the name of a good insurance company, I can provide that later. But bear in mind also that many IP infringement claims are claims of theft.
Yeah.
And it's not always easy to insure against theft.
No.
A final point on infringement, and I'm seeing more claims made against professional business advisors, whether they be insurers, accountants, marketing advisors, or resilience advisors, because if their clients are sued for infringement, many of them are now exploring the issue, the opportunity as they see it, of counterclaiming against their business advisors who should be aware and who should have advised them of this risk. So consequential liability is a big problem now for professional advisors.
Like they did in Big Four, isn't it? Big Four always, I'm ex-Big Four.
Yeah.
One of them.
Yeah. So it's definitely worth checking with your client base or your supply chain if they are protected. And if not, recommend a search, because all you have to do is recommend a search. That gets you your get out of jail free card, as they say.
Yeah. You and I will be talking.
Any other questions, Keith or Suzanne?
No, I mean, Clive, thank you very much. Very interesting. This is, I'd probably say, a bit different for me, but I'll definitely learn. It's just fascinating, as you say, and it's like very interesting. I think the Trunky example where they could have spent £60 or whatever and ended up losing 6 million of revenue. That's didn't Trunky didn't that go through Dragon's Den?
Yeah, they actually got some money through Dragon's Den as well. But often dragons are asking about IP. They did ask about IP. They did say that they had a protected design. What the dragon failed to do was further qualify how much protection that design offered, because they could have easily put in all the variations in the same design application for the same cost. They didn't.
Yeah, no, so I found it very fascinating. So thank you. And I've learned something. So yeah, thank you very much.
And what will you do differently now, Suzanne?
I'm not sure. I'll reflect on that and I'll let you know.
Okay, can I ask?
It's just be more mindful and more aware.
Yeah,
isn't it?
Yeah, definitely.
Because could you be on the receiving end of it, Suzanne?
Potentially, yeah.
So you'd be on the flip side of it.
Yeah. So yes, I'll have
3 on your risk register.
Yeah.
Keith,
Clive, could I
Yeah.
just use an example of that consequential liability? Could you maybe perhaps just give an example of something like that happening?
Yeah. So I work with a lot of marketing agencies. Many of them are doing branding work. I met one yesterday. They were working with a client of mine a year ago. Well, no, the client was working with me a year ago. I discovered through a search that their brand design was confusingly similar to the brand registration of BMW, the car manufacturer.
Oh, we won't want to go head to head there.
Luckily, as a result of that search, they immediately removed all that branding to remove the risk of a significant claim, because they've been trading for several years. Their last trading profits were £2 million. They could have lost up to half of those historical profits with that simple oversight problem. So we went through a rebrand. We've registered their new trademark. It doesn't infringe on third parties. We did a search and they're safe. And here's an example. Could have been an absolute killer for that business.
Yeah. And using Helen as an example, what I didn't realise is there is that flexibility with words in your brand, as long as you add a distinctive logo or graphics or something. So somebody doesn't have the right to try to protect or trademark a name, which I think has been a bit of a trend amongst celebrities. I think some of them have been successful with doing that for their offspring, and some haven't been as successful for, I guess, for different reasons. But yeah.
That's why I've been backwards and forwards on this, because resilience by design, I've been trading since 2017. It wasn't a phrase when I started trading with it, and now it is. In most organizations you'll hear resilience by design. I can't afford to buy resiliencebydesign.com because it's £500,000. So I was thinking, that's why I've just gone, oh well, I'll just have to change my name if it comes to it, or if someone else buys that's going to be bigger than me, I'll just have to change my name. But this sounds like it might be the solution to it. Not the solution, I won't be able to buy the .com.
Have you looked at a slight variation resilience for design? Has that ever come into your head?
It has, but I don't like it.
Okay.
It's not the
You're
same.
not that flexible then.
Much easier to use a unique typographical style,
yes,
Joe,
I've got
a
a thing.
logo.
I've got a type font that I use, and yes, I was going to say Helen, yes, I've got.
Without spoiling the surprise, I'm sure you have a particular image. Exactly.
I do have a particular image that I use.
Very prevalent with footballs, with football games. I'm going to say that because that kind of gives it away without giving.
Yeah.
Great.
Yeah. People that support a sport.
Oh, okay. Yes.
Oh, that was too tangential.
Yeah. Well, you doing that, I was going to say that's how long we've known each other.
Yeah, exactly. You know what that means. So I do think there are some unique signifiers that you can use.
Clive's just picked up a new client.
I've been trying for over a year.
I know.
I've just saved another life.
Exactly.
That's the way I look at it.
Exactly that.
Does anybody get in, Clive? Does anybody get into this purely to try and make a profit? So they're not operating as a business. They're not just trying to do it to protect themselves. But is there actually some people out there that almost use this as a way to try and generate, not in a particularly nice way, but to generate revenue?
There's a certain important man in charge of the White House at the moment who's well known as a vexatious litigant. It's very common.
So that's a high profile example,
Very high profile.
But people buying domain names simply for to stop people using them and then not use them as trademarks is actually not legal. Okay. It's so you can push them off if they're not using their trademark ownership.
Interesting, because I'm very sure I had a conversation with somebody at a networking event a few months ago about a domain name they held onto. I didn't really do anything with it.
It's called cyber squatting.
There's a name
that's
for
ringing
everything.
a bell.
There's a name for everything nowadays.
Because years ago, when the internet was in its infancy, there was a bit of a trend of people just buying lots of .coms and .co.uks.
Exactly, the .coms was the thing. And
and even
trying to get them. Yeah.
When certain small countries got their own little domain, so .tv.
Yeah.
Belonged to a small little country somewhere. I can't remember which one, but obviously it was popular because it was .tv. And I think the country themselves was selling it, different domains.
If you register a trademark and you don't use it after a certain number of years, you can be removed from ownership.
Good to know.
Yeah.
Suzanne's risk register has just gone like that.
A search will find out all these horrible things as well for you.
Yes, appreciate that. Yeah. You'd be able to identify when there are sort of dormant versions of trademarks or those kind of things. Yeah. Brilliant. Yeah. Thank you, Clive. Some very, very, very distinctive food for thought for us all. Always fascinating to talk about this area. So thank you for joining. And thank you everybody for joining this month's event. As I put in the chat, we are going to take a break in August. Recognise it's mostly summer holidays for people, but we'll be back in September when I will be talking about when plans fail. So please use the QR code to register. You will get the readout from this. You'll get a recording of this session next week, and it'll also be available on our YouTube channel. But thank you all for today, and have a great rest of your day, rest of your week, and speak to you all soon.
Thank you.
Nice to meet you
Bye.
all.
Thank you,
Thank you very
Helen.
much.
Thank you.
Bye.
A
Bye.
hot topic for a hot day.
Indeed. Thanks, Clive.
Thank you very
Cheers.
much.
Bye.
Bye bye.